Hi, my name is Marty Shankman. This is Elvis, and this is a video series entitled Elvis Does Estate Planning. Hi, my name is Marty Shankman. This is Elvis, and this is a video series called Elvis Does Estate Planning. And this particular video is about what is a fiduciary. I want to define the term. It's a person in a position of trust. It's probably the most critical decision to repeat it, that you will ever make in your estate plan. Who's going to be the executor of your will? If you die and you set up a trust for a minor child, who's going to be the trustee? These are the single most important decision in your plan, because if you name somebody that's unethical or insensitive, you agree? You want a pet trust with a nice trustee? You've got to have the right person named. So let's talk a little bit about what a fiduciary is, each of the different common types of fiduciaries you have to name, because again, to repeat myself, this is the most important decision for you to make. And it's really something that while a lawyer or estate planner can give you some guidance, you're not happy, guy. It's an interesting topic, Al. All right, we're going to put you down, okay? You go down. While a lawyer or estate planner can guide you, you have to really think this through. And you got to be honest with yourself and not just name somebody because you feel obligated to name them. You have to name the people that will do the job right. That's not easy politically, because Uncle Joe may be the one everyone in the family turns to for investment advice, but is he really competent and capable of managing your kid's money if something happens to you? So let's go through each of the different fiduciaries. And again, remember the definitions, it's a person in a position of trust. And as we define the people and the roles, I think the definition will make more sense. The most common that everyone thinks about is an executor, or sometimes it's called personal administrator. The terminology varies wherever you are in the country. That's the person charged with managing your estate. So when you die, if you have a will, the person you name as executor or personal administrator, their job is to marshal or collect all your assets, pay all your debts, distribute all your money. Think about what that role is. It's somebody that has some business acumen. They don't have to be an investment expert. They can hire somebody, although in the market the way it's looked in 2008 and 2009, I'm not sure who's been the guru or expert in that. But they need to have some sensitivity and awareness to be able to deal with investment people. They're going to have to deal with the lawyer that's going to handle a lot of the legal issues. If your estate's really simple, you may minimize your legal time, but you never should really eliminate having a lawyer involved. And if we have time, we'll do another video on probate and that process as well. So the executor is somebody that really is dealing with business, financial, maybe tax if your estate's large enough issues. They're dealing with administrative matters, accounting and record-keeping matters. You want somebody trustworthy. You want somebody also that's sensitive and compassionate to the beneficiaries, because it's an emotionally traumatic time for most people when a loved one passes away. And the way the executor handles it can be just as important as the how they handle it. So that's probably the most common fiduciary you have to name. Now, as we go through these, bear in mind, you don't have to name the same person or groups of people for each role. In fact, a lot of times it's better to have multiple people or different people in different roles, so there's some checks and balances on who does what, and we'll talk about that. The next most common type of fiduciary is a trustee. If you set up a revocable living trust, and we'll have another video clip just on that topic because so many people talk about it, we'll dispel some of the misconceptions about that topic as well. But the person named to run that trust is called a trustee. The generic term is a fiduciary, and the person that's the fiduciary for your revocable living trust is a trustee. It may be you. Oftentimes it shouldn't just be you. It may be you and another person. If you have two people named together, they're called co-trustees, and that's a great way to have checks and balances. One of the most common ways for many people to name a trustee, especially if they have significant wealth, but it's something a lot more people should be looking at, is naming an institutional trustee, a bank, a trust company, along with an individual. So you could have Uncle Joe, your trusted favorite uncle, serve as a co-trustee with a major bank or trust company, so that you get the professional money management, the independence. If there's a problem where a kid wants money that they're really not entitled to, and it may be hard for Uncle Joe to say no, maybe the bank has no problem saying no if that's what you've directed. So the trustee is another major fiduciary function that you have to name, and be a little creative to make sure you accomplish your goals. It doesn't have to be just one person. You can name co-trustees together. And a lot of times by combining different attributes of different people, you get a much better result. The toughest fiduciary of any to name is the guardian. God forbid you die and you have a minor child. who's going to take care of that child. Bear in mind a couple of problems and issues that people have when they name guardians. And we'll have another video clip on how to take care of your children. We'll talk about some of the related issues as well. You don't probably want to have the guardian the same person that's the trustee, because then you have the fox watching the hen house. Maybe you have the guardian as a co-trustee with a bank or with Uncle Joe, so that the guardian can have some input on how the money is spent to care for your children. But if the guardian is the same person that's the trustee, who's watching shop to make sure they're really taking care of your kids correctly in the way you want? Another issue with guardian, when you point to guardian, name one person. If your brother is the person you want to name as the guardian, don't appoint your brother and his wife. What if they're divorced? The last thing you want to put kids through that were just traumatized by the loss of their parents is a divorce battle where the two people named as co-guardians are fighting over who's the guardian for your kids. And don't put it by anybody that the money involved, if they're the guardian and have guardianship over the children's property, may not be an ulterior motive. So consider how you structure it and what you do. Another common guardian is everybody over age 18 should have a durable power of attorney. It's a document that appoints an agent, a person called an agent, who's a fiduciary, to take care of tax, legal, and financial matters if you're disabled, not if you die. If you die, it's invalid. That's when your will kicks in. So a power of attorney of the agent is a very important thing. For many people that get on in years, senior citizens, people that have a chronic illness, it could be one of the most important functions that you have. We'll have a whole separate video clip just on powers of attorney, explaining them and how they're used. The next category of fiduciaries to name are those that are given medical powers. So under a healthcare directive, medical directive, enhanced directive, healthcare proxy, it's known by a lot of different names, you're going to designate someone to take care of medical decision making for you. Now contrast that with the guardian and contrast both of these with the financial kind of powers like under a power of attorney or the executor or the trustee. These roles, even though they're all fiduciaries, could be very different. The person you feel comfortable making a medical decision for you may be totally inappropriate to be a guardian for a minor child, and they may be totally inappropriate to be a trustee. So you may have a child, a daughter that's a doctor. She may be ideal to take care of medical decision making for you, but she really may not have the financial acumen, or even if she does, she may not have the time because of her demands of her practice to be a trustee or to be an agent under your power of attorney. So you don't have to name the same people. And again, as we started this discussion, don't name somebody because you feel you have to. Oh, gee, I have to name my oldest son because he's going to be insulted. It's not about insulting your oldest son. It's about doing what's right for you and all of your loved ones, not somebody's particular ego. And that makes it a tough project. The final fiduciary I wanted to comment on, if you have a minor child, there's a form. And by the way, you can get some of these sample forms that you can review with your lawyers for free on the LawEasy website, www.laweasy.com, is to name somebody to make medical decisions for your minor child if you're away. So you and your spouse or you and your partner are off on a safari for 3 weeks in Kenya. What happens if, God forbid, your child gets sick? Will the nanny or your sister, whoever's watching the children, have the legal authority? Will they have the knowledge? Will they have the information they need to take care of your child? So that's another different role that you need to name somebody for. So let me summarize and then we'll conclude this video clip. Let me rephrase that. The most important decision in your entire estate planning process is naming the right people as fiduciaries. You can do all the greatest planning in the world and you name somebody that's unethical or insensitive or ignorant or not quite the right person, you can undermine the best plans. You need to look at the planning in a much more sophisticated way than most people do. It's not just one person fits all. Each different fiduciary role should have the right person, or as we discussed, co-people as co-trustees, co-executors, co-agents named. Bear in mind when you name co-agents that for a healthcare proxy, in most states it's illegal to do that. You can only name one person under a healthcare proxy. And one final comment. It's not just enough to name Uncle Joe in a bank. If Uncle Joe is disabled or dies or retires or just doesn't want to do the job for you, you need what's called a successor. So for every single one of the roles we've named, you want to name at least 2, and if possible 3 or more, successors to serve if the named person can't. And whatever document you have an attorney draft for you should make it very clear what the order of sequence is and how people can be replaced and changed if there's a problem. Thank you for joining us.